If Congress drives a gun tax down to zero, what business does the federal government have keeping your name in a felony registry for almost a century? The National Firearms Act has been Washington's choke chain on ordinary gun owners. You paid a $200 stamp, gave up your fingerprints, sat in limbo for months, and waited for ATF to allow you to keep a suppressor or short-barreled rifle you already owned responsibly. However, in 2025, under the so-called One Big Beautiful Bill, Congress quietly reduced the NFA tax on suppressors, SBRs, SBS, and similar items to $0 while leaving the registry, the paperwork, and criminal penalties in place. Now cases like Brown v. ATF, backed by major gun rights groups in 15 states, are asking the courts whether the government can keep the control after it has surrendered the tax. So let's zoom out for a second and talk about what we are actually fighting over here. For almost 100 years, the National Firearms Act has lived inside the federal tax code as this weird Frankenstein of taxes, registration, and felony penalties. Instead of saying, "We're banning your gear," Congress in the 1930s said, "We're just going to tax and track it." That's why the NFA sits in the same chapter of the Internal Revenue Code as alcohol and tobacco rules, and why for decades you had to send in a $200 check, fingerprints, photographs, and a detailed form to ATF just to put a suppressor on a rifle you already owned responsibly. Back in 1934, that structure gave the federal government political cover. Lawmakers could tell the courts, "We're not creating a national gun control code. We're just using our power to tax certain especially dangerous weapons." The Supreme Court adopted that logic in cases like Sunzinski v. United States, treating the NFA as a revenue measure first and all other considerations second. That old understanding matters because it's the entire legal foundation on which the government still stands when it defends the NFA today. Fast forward to the modern fight. Over the last decade, an increasing number of ordinary shooters have moved into the NFA world. Suppressors have evolved from niche toys to common safety equipment for hunters, competitors, and people who simply want to protect their hearing at the range. Short-barreled rifles turned into the standard layout for home defense and duty use. At the same time, many state legislatures, especially in places like Texas, Oklahoma, and Utah, have liberalized their own laws, recognizing that these items are normal tools, not gangster weapons from a crime movie. For years, people thought the answer would probably come from Congress through bills like the Hearing Protection Act and the Short Act. Those were supposed to remove suppressors and certain short-barreled firearms entirely from the NFA. But when the dust settled on the big budget package, now nicknamed the One Big Beautiful Bill, those full deregulation pieces didn't make it into the final law. Instead, Congress quietly chose a different path. They drove the NFA tax on suppressors, short-barreled rifles, short-barreled shotguns, and similar items down to $0, while leaving the skeleton of the old system standing. The registry stayed. The transfer paperwork stayed. The felony penalties stayed. On paper, it still lives inside the tax code. In reality, there's no longer a tax doing the work. That's the crack in the foundation that this new wave of lawsuits is driving a wedge into. So, who's swinging that hammer? And what exactly are they asking the courts to do? At the center of this wave is a case called Brown v. ATF, backed by groups like the American Suppressor Association, the National Rifle Association, the Second Amendment Foundation, and the Firearms Policy Coalition, along with individual gun owners who are tired of living under a system that treats common tools like contraband. On a parallel front, you've got industry players stepping in major retailers and manufacturers like Prime Protection STL, teaming up in related challenges. Together, they're filing suits in federal court that all boil down to the same basic question: if there's no longer a real tax on these items, how can the federal government keep hiding behind the tax power to run a nationwide registry? Their ask is straightforward but huge. They want a federal judge to say out loud what Congress was hoping to skate past quietly, that the registration and transfer scheme for untaxed items like suppressors, short-barreled rifles, short-barreled shotguns, and certain specialty firearms is no longer tethered to any legitimate taxing purpose. If there's no revenue, there's no tax. If there's no tax, there's no tax program to justify fingerprinting people, forcing them into a federal database, and threatening them with prison time because they didn't get government permission before bolting a can on the end of their barrel. And they're not just asking for a symbolic ruling, they're asking for something with teeth. They want the court to block ATF, the Department of Justice, and any other federal agency from enforcing the NFA's registration and transfer rules against these untaxed items going forward. In plain terms, if they win, a law-abiding American in Texas or Georgia could buy a suppressor the same way they buy an ordinary rifle today, pass the standard background check, follow state law, and go home, without being dragged into a separate federal felony scheme that no longer collects a dime in tax. One of the most powerful pieces of this fight is the role the states are playing. In related challenges, 15 Republican-led states have stepped into federal lawsuits to argue, our citizens are being harmed by this structure that's not just political theater. That's a sovereignty argument. These states have already decided at the state level that suppressors and short-barreled rifles are lawful and useful. Their residents are still being forced, at the federal level, into months-long waits and massive legal risk under a law that, in its modern form, looks less like a tax and more like a permission slip, by putting their names on the complaints. Those states are telling the courts this is not some fringe internet issue. It's a serious federalism problem. And it's time for a judge to say whether Washington is still allowed to call this thing a tax when the tax has been set to zero. Underneath all of that is a simple constitutional question. The Supreme Court has already told Congress, in other contexts, that there's a distinction between a real tax that raises money and a regulatory penalty that just tries to control behavior. When Congress itself has dialed the NFA tax down to nothing and left only the control, these lawsuits are inviting the courts to admit that the old justification no longer fits. Either the government finds some other honest source of authority for this registry, or it has to let go. Now here's where the strategy clash really shows up. The gun rights side is trying to slam this case straight into a ruling by filing what's called a motion for summary judgment. In normal people's terms, they're telling the judge, we don't need a big jury trial. The facts aren't in dispute. Congress set the tax to zero. The registry is still running. The only question left is a legal one. You can decide this on the papers, in Brown v. ATF. That motion was filed on November 14, 2025, according to updates from SAF and FPC. On the other side of the field, the Department of Justice and ATF have been doing the exact opposite, putting the brakes on every chance they get. In October of 2025, when the federal government hit a shutdown and there was a lapse in appropriations, DOJ marched into court in similar NFA cases and said, we don't have the money, we don't have the staff, we can't assign attorneys to this case, so please just put everything on ice indefinitely. The judges have refused open-ended pauses, but granted short extensions, often about a week, to get their house in order. In one related challenge, the original deadline for the DOJ to respond to the plaintiff's motion for summary judgment and file its own cross-motion was set for November 13, 2025. As the date drew closer, DOJ came back and asked for more time again, this time blaming staffing shortages and other emergency litigation they said their lawyers were juggling. The court grudgingly moved the deadline out about a week, to roughly November 20th. Meanwhile, the plaintiff's own summary judgment briefing is already on the judge's desk. Put all of that together, and you see the pattern. The plaintiffs are seeking a clear, early ruling that states, no tax, no registry. The Trump-era Department of Justice is doing everything it can to slow the clock down while still defending the NFA as constitutional. This isn't new. In other NFA and gun rights cases in the district courts, the courts of appeals, and even when issues brush up against the Supreme Court, this Justice Department has consistently taken the position that the NFA is valid, that it doesn't violate the Second Amendment, and that these kinds of restrictions are here to stay. Every week they push this case down the calendar. The old NFA structure keeps grinding away. People keep sending fingerprints. Dealers continue to log into the e-form system. Families keep waiting on approvals that make no revenue for the Treasury, but carry all the risk if a form is filled out wrong. For the plaintiffs, delay is not neutral. Delay means rights denied in practice, even if a court someday admits the government went too far. There's another layer to this that we can't ignore. And that's the modern Second Amendment framework after New York State Rifle and Pistol Association v. Bruin. In that case, the Supreme Court said clearly that you can't just wave around generic public safety concerns and call it a day. If the government wants to restrict the right to keep and bear arms, it must point to a historical tradition of similar regulations from the founding era or shortly after. No more balancing tests. no more we think this will reduce crime. So trust us. So even though this new wave of NFA lawsuits is leading with the tax power argument, the Bruin standard is sitting there in the background like a second blade. Suppressors and short-barreled rifles are no longer exotic curiosities. They're widely owned, heavily regulated, and used every single day for lawful purposes: hunting, competition, home defense, and basic hearing protection. There is no historic tradition of forcing citizens into a centralized federal registry, backed by felony penalties, just to own common arms or accessories that millions of people are already using safely. That's why these cases are so dangerous to the old NFA model. If the government somehow convinces a court to relabel this scheme as a pure public safety regulation or a Commerce Clause program instead of a tax, that does not end the conversation. Under Bruin, they still have to prove that a sweeping nationwide registry of suppressor owners matches what the founders would have recognized as a legitimate tradition. That's a tough sell when, for most of American history, the federal government didn't even attempt to license or register individual gun owners at all, let alone people who wanted to put a muffler on a hunting rifle. So where does all of this actually go? And what should you be watching for as this plays out? In the best-case scenario for gun owners, a federal judge looks at this structure and says, "Enough." The court rules that for items where Congress has set the NFA tax at zero, the government can no longer pretend this is a tax program. The registry, the transfer approvals, and the felony penalties for untaxed suppressors and short-barreled firearms would no longer be enforceable on that tax theory, at least in the jurisdictions covered by the ruling. There's also a messier middle path, and this is the one a lot of legal commentators worry about. A court could admit that the tax rationale is weak, but then try to save the NFA by re-anchoring it in some other power, like interstate commerce or a broad public safety theory. On paper, that would look like a win for the Department of Justice. In practice, it would mean the same registration machine keeps running under a different label, and the same ordinary Americans keep facing the same risks. And of course, there's always the possibility that a court ducks the core question, or upholds everything and invites higher courts to sort it out. If that happens, the fight doesn't end. It just moves up the ladder. Either way, these cases are going to define how far Washington can go in using technical statutes to control a constitutional right long after the money has stopped changing hands. At the end of the day, this fight is bigger than suppressors or short-barreled rifles. It's about whether the federal government can keep a 90-year-old control scheme alive after Congress has stripped away the tax it was built. These lawsuits are moving fast, and the next rulings will tell us a lot about how far Washington can still reach into your gun safe. I'll be tracking every filing, every deadline, and every decision that comes out of this battle. If you want to stay ahead of the rulings that shape your rights, make sure you like this video, subscribe, and stick with me for the updates that actually matter.